Welcome to Commercial Real Estate Pro Network CREPN Radio. Thanks for joining us. My name is J. Darren Gross. This is the podcast focused on commercial real estate investment and risk management strategies. Weekly, we have conversations with commercial real estate investors and professionals who provide their experience and insight to help you grow your real estate portfolio. Today, my guest is Brian T. Bradley, Esquire. He is the leading educator and nationally recognized asset protection attorney for high-risk professionals, entrepreneurs, real estate investors, and ultra-high net worth families. Brian's goal is to give you peace of mind knowing your assets are protected. And in just a minute, we're going to speak with Brian about asset protection, the risk real estate investors face, and what you can do to protect yourself. But first, a quick reminder, if you like our show, CREPN Radio, there are a couple of things you can do. You can like, share, and subscribe. And as always, we encourage you to leave a comment. We'd love to hear from our listeners. Also, if you want to see how handsome our guests are, be sure to check out our YouTube channel. And you can find us on YouTube at Commercial Real Estate Pro Network. While you're there, please subscribe. With that, I want to welcome my guest. Brian, welcome to CREPN Radio.
Oh, thank you very much for having me on and putting the whole podcast and everything together. And it's a really important topic, and I hope that the concepts that we talk about help your listeners. And, we're definitely going to be blowing up the status quo and, all the misconceptions out there.
Cool. Well, I'm looking forward to it. Before we jump in, if you could take a minute and share with the listeners a little bit about your background.
Yeah, like you said, I'm an asset protection attorney, and I got into asset protection from the litigation side of the law, and having clients being sued and their lives just turned completely upside down with a false sense of security, thinking, well, I have insurance and I can just rely on that. I don't need anything else, or, sticking all their assets into a revocable living trust and thinking that that's going to protect their assets from lawsuits, and then finding out that that's not going to do anything for them. And, by being in the legal system, the sad thing is that the legal system is just broken. It's not about justice any longer. In the US, we're a sue happy nirvana. We have more than 40 million lawsuits filed every year in the US. And, litigation has just become a over $400 billion business with a B. And so what we do is provide peace of mind for clients. And we keep in mind really the overall goal of asset protection is lifestyle preservation. When the client calls and says, hey, Brian, I want to talk to you about asset protection, what they're really saying is, I just want some peace of mind. I want to get rid of some stress, and I want to preserve my lifestyle in case something bad happens. And it really just comes down to, more importantly, how collectible you are. And we do this by placing different legal barriers between your assets to the proper uses of, LLCs, LPs, different types of asset protection trust, which are more flexible. And what my firm specifically does is work with, high risk professionals and investors who generally have around 1 million net. And with our bridge trust or a quantum living trust for those below 1 million, we've collectively protected over 4 billion worth of assets now.
No, that's great. And so if I heard you right, you came from the trial side of things?
Correct. Yeah.
Okay.
I came out of law school right when the recession started, 2008, 2009, and was about to, have a hand-given job to a prosecutor's office. And then there was hiring freezes across, the whole state of California where I was at. And then I ended up getting into civil litigation, same thing, but no money in that industry. No one was able to pay bills, or, clients weren't able to pay. And so I literally just worked for free, no joke, for 3 years. I went to different state agencies and said, look, you have a lot of people who need representation. I need to get into court. I'll do it for free. You cover the court costs. And I did that for 3 years. And just, you think about how many people want free representation at that time, or in any time. And I ended up building such a big name and experience for myself in the trial world that in 3 or 4 years, I had more trial and litigation experience than most people with 25 years of practice. And then that trickled down into, becoming a legal janitor of essentially, hey, we're stuck in this trial. We don't know what to do or how to do it. We have no litigation experience. Can you come in and help, and be a miracle worker? So I started getting hired case by case and built up to like $40 million cases. And I just got tired of seeing people come in after the fact. And that's when I wanted to transition my practice to being proactive and helping people protect their investments, protect what they have, all that hard work and energy you put into building your portfolio and legacy before something bad happens. And specifically also because I like to invest myself. Last thing I would want to see is everything I'm working hard to pass on to my kids and my grandkids down the line be completely wiped out and nothing I can do about it.
That's your experience there, I'm sure, is one that not every attorney has. I'm kind of curious, in your experience, kind of being the hired gun there to come in and work on trials and that. Do you have any sense of how many attorneys actually get experience in the courtroom as opposed to uh, more just legal work there?
Not many. And even just trial work, not many, because there's you have transactional attorneys like real estate, business, stuff like that. And then you have litigation attorneys. Most litigation, 99% of it settles. It's in both parties' best interest to settle. It's a matter of how do you force that settlement? And that's a big play of what asset protection is if you have systems that are created really strong and they're seen as impenetrable, you are now in the position of strength. You now have the legal negotiating leverage to force a case to go away or to settle it very, very cheap. And I really wanted to incorporate that into my practice. But 99% of cases that get filed, they're just getting filed for a settlement. You just have to go through the expensive litigation process. So most even litigators don't have a lot of trial experience. So they wouldn't know how to run a trial if they needed to. So I really focused in the beginning on how to run a trial, how to talk to a judge, how to talk to a jury, jurisprudence, how to pick a jury, how to create arguments and triangles that you would need to prove a case. Not many people actually have that type of background and experience. And so it was even hard to find mentors and really good mentors. So I reached out to just like the best of the best, Friedman, David Ball, Gary Spencer, and these guys, and just said like, these are the best of the best of this. I'm just going to copy success. And I always made a point to where I don't care if cases are going to settle. I always take two cases to trial every year just to keep developing those skills. I just pick really interesting cases now that changed the law in the state because I'm able to cherry pick now.
No, that's awesome. I appreciate you sharing it. So let's talk about asset protection.
Yeah.
You mentioned that, people were coming to you kind of after the fact, as opposed to, when essentially they couldn't do anything. It was too late. What can you, there's multiple levels of asset protection. As an insurance broker, I like to think that we participate in asset protection as one of the easy, options. But can you kind of break down the different, levels or the different types of asset protection that are available?
Yeah, absolutely. And I think, a good starting point is just understand like what even is asset protection. Like we hear the word, but I don't think very many people even understand what it is as a basic conceptual level. And it's just modern estate planning fighting modern wealth destroyers. Like we're not talking about taxes, death taxes destroying wealth, and what we're really talking about are predatory lawsuits, an out of control legal system, out of control legal costs, divorces. These are the things that destroy your wealth while you're alive. Living wills, revocable living trusts, and stuff like that only come into effect once you die. So there's no protection that's even going to be coming out of that. So replacing a legal barrier between your assets and your potential creditor before it's needed. It has to be done before you're under a gun, before you're being sued, because if we start transferring assets after the fact, after you're sued, then we're going to be looking through fraudulent transfer arguments. And so courts like asset protection done before you're being sued because it's preventative, just like insurance is preventative. That's it. It's like a safe that you would put, your gold or your guns or your watches or other valuables in. Anything of value as an asset wise, you also want to put behind a legal barrier or a legal safe out of your personal name so that it's not easily attached with a lien, or reached with a judgment. Like we have a saying, we want to make you as ugly as possible to a creditor, which is kind of against human nature because we all want to, look good, take care of ourselves. when it comes to litigation and lawsuits, you want to be seen as unattainable, very ugly to collect on, very expensive and difficult, and not worth anybody's time to attack. And we do this through different layers. And the general layers would be, an LLC, limited liability company, an LP, a limited partnership, and a variety of different types of asset protection trusts. And, there's lots of different flavors of trust. And we can break all these concepts down in a little bit. And like you said, insurance is an entry base level layer. You got to have insurance, but I think most people just need to understand when it gets into litigation world of things, there's things called insurance defense teams whose job is to create legal separation from you and not pay claims. So you should have it. You should have it for, as much as you can afford, but you also understand that, insurance doesn't cover you for fraudulent acts. They don't cover you for intentional wrongdoings. And in litigation world, that's what the insurance defense team are going to start implying is intentional acts and wrongdoing arguments to create wiggle room for large judgments to say, hey, we're not going to be able to cover this because of an intentional act, which can be as simple as you sending an email, because a judge will look at that email and say, you wrote this, writing is an intent. Now that just transitioned that whole case into an intentional potential wrongdoing. And that's now the legal separation in trial that an insurance legal team is going to use to pay down less of a claim.
And just for clarification, this insurance defense team you refer to, that's essentially the insurance companies working to protect their assets. Is that correct?
It's the insurance. It's the insurance legal team looking at a case and deciding, are we going to pay this claim? Are we going to pay this claim in full? And insurance as a business make money by taking premiums and not paying out large amounts of claims. So they're going to look at a case and say, here's $1 million claim potentially. Are we going to pay this or not? Where's the legal separation? And they're going to protect their own interest.
Gotcha. So you mentioned multiple things. I mean, layers, LLCs, LPs, and trust.
Yeah.
Can you go into each one of those and share kind of what the construct or what the protection they provide? And I don't know how deep you want to go, but just some sort of a way to explain that for the listeners to kind of identify and recognize what each one can do.
Yeah, absolutely. And so we're just going to call it, the key concepts and tools of asset protection. And like you said, like LLC, LP, and an asset protection trust. And so I think the best way to conceptualize it is to think about winter. When it comes to asset protection, we have different layers. I'm from the mountains. I'm originally from Lake Tahoe. We get lots of snow. I also lived in Michigan, where it's freezing out there. And so we learn how to dress in layers. The first layer is your base layer. It's generally made from merino wool and it sits on your skin. That's going to be like your LLC and your insurance. And then you want a layer, which is usually a little bit thicker and it can be synthetic wool. That's going to be like your limited partnership. And then you want an outer shell layer, a waterproof layer. This is going to be your asset protection trust. This keeps you nice and dry and warm when the weather is, really cold and bad. But by layering, you're now more flexible. When it gets hot and you're skiing or you're ice fishing, you can take the outer layer off, the inner layer off, the middle layer off. You can adjust and make yourself more comfortable. And the same thing applies with your asset protection. And so to break each one of these layers down, the base layer, like I said, is your LLC. And it's holding, for example, your real estate. Your mid layer is going to be, the limited partnership. And you generally will be looking at that mid layer to be in a good state that has some good protections like Arizona, Nevada, Wyoming, Delaware. All the base layer LLCs, you want those K1s to be able to flow directly through to the management company. And so we want those to be single member layers as long as you're using that mid layer limited partnership. The problem generally is that most clients come to me with 15 LLCs and they're all single member LLCs, but they're also all in that client's personal name because they had their CPA create them or someone who doesn't know much about asset protection create them or they created them themselves. And so the problem with this is that courts have a tendency to fully disregard single member LLCs now. And so they're basically worthless. What you want is that single member LLC that's holding your real estate to then be held and owned by a multi-member limited partnership, not you personally. And so by doing this, what you're now doing is properly layering your asset protection system. And then people really do have a lot of confusion on where to set these up, where to set these LLCs up in, because they're thinking about charging orders, but they don't really understand the concept of this. So you go to Delaware, Wyoming, Texas, Nevada, and you hear about these states, they're really good. They're really good about protecting the LLCs, and some of these states have privacy. So people say like, oh, it's better to do that. So I'm going to go do that because I read some blog or my CPA told me about this, but my CPA is not a lawyer, but I'm just going to do it anyways. It really comes down to an issue of just what are you holding? So let's say, for example, it's California real estate you're holding and you set up a Wyoming LLC because somebody on the internet or your CPA told you that it was better to do. And you go ahead and hold a key piece of California real estate in it. You're also a California resident and you're paying California franchise tax. What you've done is just convert your Wyoming LLC to a California LLC because you're doing business in the state of California. And not only are you going to be paying the California franchise tax, but if you ever do have liability, like meaning you're being sued, a California judge isn't going to care, like about your Wyoming LLC. The law that's going to be applied is the law from California because that's where you reside, that's where the injury resides, that's where the property is, that's the jurisdiction. And the same thing applies for any other state. So general rule of thumb is that for your real estate, you want to create the LLC in the state that the asset is in, because that's where the lawsuit's coming from. Those are the rules that are going to apply. That's where the jurisdiction is going to be. All you're going to be doing by using states in another state is doubling your maintenance cost. And so just remember the rules, the laws don't transfer. And then I hear a lot of confusion about series LLCs. And so the big misconception with series LLCs is that there's not really any case law around them. So with no case law to rely on, there's only a few states that have series LLC statutes. What this means is that if you live in a state that doesn't recognize series LLCs, you won't get the benefit that's intended from them. So just realize I only use and recommend series LLC structures for clients that reside in a state that has series LLC legislation and the assets in a state that has series LLC legislation. Otherwise, it's not going to be recognized. So you got to remember, what states are you in?
Real quick, states, you said there are some that do recognize that. Can you identify those states? I mean, I've heard this term and didn't really.
Like Texas is a great. Texas has series LLC legislations. I believe Ohio does, and there's some more that do, but most states don't. For example, the entire West Coast, California, Oregon, Washington, they don't. So California, for example, and I'm probably like, people are like, why is this guy bashing on California so much? It's just an example. There's so many people there, a lot of money there. And California will not recognize a lot of type of entities. So that's why I use California as an example a lot. What they're going to do is just say, great, I'm glad you created a series LLC structured with children LLCs underneath it. We don't recognize that. We don't have a series LLC structure. We don't have series LLC statutes. So your children's series are not going to be recognized. It's just going to be seen as one LLC. Any asset that blows up bleeds into all the other ones. And they're still going to charge you, surprisingly enough, the franchise tax on each single series LLC that you made. So you're paying the franchise tax on each one of those sub LLCs, but you're not getting the benefit of it. So you really have to look at, where's your residence at? Where do you reside? Where's the liability going to come from? Where's the asset in? And see what works in those states. And so it's really big things that you need to go through a legal analysis of to find out what works. And then and then the next big misconception with LLCs that I get is the term anonymity, and the thought that you can just create an anonymous LLC and that you just disappear and can never be found. Like, this is just completely false. When your LLC is sued, you're going to be legally required to appear and defend it. If you don't, a default judgment is going to be entered against you. Then the complaint will simply be amended and you're going to be named personally. And also the simple reality is that once a lawsuit's filed, the discovery process begins and you'll be subpoenaed and forced into court. And what's even worse is that if you want secrecy, anonymity to even work, this is also known as lying under oath. And so that's a one-way ticket to jail. And so an example of this is that very shortly after a judgment is going to be entered against the debtor, meaning you, the creditor has the legal right to demand information about the assets that are owned and by you, and the courts enforce this very, very broadly and take it very, very seriously. So at this point in litigation, the only way to keep an asset anonymous or a secret is to lie about them and commit perjury. And so that's why we don't advocate for hiding. We just prefer to have full disclosure of proper, of assets, and just have a proper asset protection plan that's in place. And so to do that, this is the first two layers. Like you have an LLC, and then you have limited partnerships. The limited partnerships is just a step up of a class of an LLC. That limited partnership would own your LLCs. Those LLCs would own the assets as holding companies. And then you bring it together, and it works best together when you add a bridge trust or an asset protection trust to it.
Gotcha. Well, it's interesting, all the LLC stuff there. I mean, I know I've heard the series LLCs and finding the state far and wide that charges the least. And like you said, if you live in the state and the property's in the state and the suit is in the state, nice that you had that LLC, and that I think Wyoming is one that I've heard people like a lot. But the court doesn't care. I mean, they're going to find out, and like you said, even with discovery, they're going to find out who you are. I also wanted to go back to, you mentioned that the single member entity or the disregarded entity, that the courts basically are. I mean, is there no protection with that? I mean, does it give you any protection?
It gives you some. It gives you a base layer level of protection. But like all LLCs, like the very first word, limited, they don't hide the fact that LLCs are not created to be a magical, you have no liability. It's just all going to go straight into the corporation. It's very limited. And then you pierce the veil. Some states have good charging order protections, like Arizona, Texas, Delaware, Wyoming. The strength of it is like, are you a resident of that state, and is the asset in that state? Because I'm not going to be transferring charging orders from Wyoming to California. So that's the importance of multiple layers. But to get to the question of, the single member LLC, the piercing the veil has completely destroyed the strength of the LLC. And it is now so easy to pierce a veil, especially for real estate investors, that this is the importance of having multiple layers of protection. And then depending on where you get in the net worth of the sliding scale, a really strong asset protection trust, which we'll bring next. But piercing the corporate veil, just as a real estate investor, is two easy arguments that work on 9 times out of 10. An extension of yourself. You're holding that real estate as a holding company, the real estate in a holding company. It's not doing business. It's just a holding company for an asset you own. Right there, that's going to be a piercing the corporate veil argument that wins 9 times out of 10. Then the next one is commingling of assets. Most people do very, very poor accounting. And so you're bringing business money in to your operating company or that LLC. You're transferring it incorrectly into your personal account into that account. You're commingling money back and forth. You're using that business as a personal extension of yourself. So just making those two arguments right there, I'm going to pierce that veil. And most young attorneys can make those two arguments without even thinking about it. And depending on the state that you're in, they'll win all the time. And so that's why these single member entities are just essentially becoming worthless. It creates the level of the separation, which you want. It's an entry point. You got to have something. It's better than nothing. It's just going to cost a little bit more money for the person suing you to pierce that veil.
Got it. So we talked about the base layer being the LLC, the mid layer being more like a limited partnership. And you said that the limited partnership then is the single member of the LLC. Is that right?
So the limited partnership, you broke up on your question. So I'm assuming you're like, what's the role of the limited partnership in that? And the limited partnership is the managing member of the LLC. It's the owner of the LLCs. And then you would be the managing member of the limited partnership, and your spouse can be, and you can set up succession planning through that limited partnership. The great thing about limited partnerships is they have 2 classifications of ownership, a general partnership and a limited partnership. The general partnership's going to be owning all the LLCs. Like if you have passive syndication shares, they're going to go into that. You're going to be doing your receivables through there with your bank account. That's going to be doing the management, the business end of it, the face part of everything. All those separate LLCs will be owned in that general partnership, which makes all those separate K1s flow straight through. One tax filing cleans it up. Your CPA will be happier about the number of hours, but not so much because his billable hour rate will go down on that. So, it makes your system cleaner. But then the second great thing about limited partnerships are the ownership interest is separate. So that's where that asset protection trust comes in and owns that limited partnership. You're the beneficiary of the asset protection trust. And asset protection trusts are very special because they're called self-settled spendthrift trust. This means they're created by you for yourself as your own beneficiary. And then you can create them in two different areas, offshore or onshore.
Oh, so you can literally go offshore, and that basically then is that another layer of tax? I mean, is that a tax strategy then, or is that more of a legal strategy?
No, it's a pure strength strategy.
Strength.
Yeah, we don't asset protection to work. It needs to be tax neutral. If you call and they're like, "Hey, I want to lower my taxes and start, putting money overseas," I would say go talk to a CPA or wealth manager guy about that. Asset protection needs to be done tax neutral, not for tax avoidance because that's fraud against the law, or for hiding assets, or from known creditors. But the reason that we'll just break down like asset protection trust, and it'll kind of answer the, question itself. So the jurisdiction, you can go offshore in the Cook Islands. They created asset protection trust about 40 years ago in 1984, the famous Cook Islands. What jurisdiction means and why it's so important is that the laws and rules that govern you and trust and business entities are different, from one jurisdiction to another, meaning one country from another, one state from another, even one county from another. Think about criminal law movies or old Westerns where a body falls on the county lines. Like, that's my jurisdiction. No, this is my jurisdiction. They're just trying to figure out and fight over who controls the laws for what's going on. You have two options when you create asset protection trusts. Like I mentioned, you can go offshore or you can do them domestically. The Cook Islands, I prefer just because they have what's called statutory non-recognition. That's why an offshore foreign Cook Islands asset protection trust is still the global gold standard after 40 years. What this means is that a U.S. judgment is completely worthless in the Cook Islands. You have to start your case all over from scratch. You're going to be facing the highest legal standard in the world, the murder standard, beyond a reasonable doubt, to prove a civil case through. The plaintiffs have to front all the court costs and fly in a judge from New Zealand. You can't take your U.S. attorney with you there. There's no contingency fee attorneys there. And if you lose, you pay. And we don't have that type of system here in the U.S. So just the barriers to entry are almost impossible. And there's only a 1-year statute of limitations. But, there's pros and cons to everything. To be purely foreign, not everybody needs that level of protection. For most, it's just overkill. And honestly, to be purely foreign, it's a hard pill for a lot of people to swallow because of the cost, generally like $50,000 or more. And there's extra IRS reportings and disclosures that have to be done. So what happens is most clients will just settle on a domestic asset protection trust. They came about 10 years later. And interesting enough, the Cook Islands creators of the asset protection trust came to the US to help create our asset protection trust. Of all places, Alaska started first, and then, Wyoming, Delaware, Nevada, like once one state does it, they're going to get in on the game. So now we have over 20 states with domestic asset protection statutes. The problem with purely domestic asset protection trusts is that they fail on effectiveness. This is because of the US Constitution, the full faith and credit clause. And so now we're seeing a pattern of domestic asset protection trusts being pierced in court. For example, California doesn't have asset protection statutes. And so what you have with a lot of California residents is going out of state to Nevada. So they create an out-of-state Nevada asset protection trust. Well, there's a case, Kilker versus Stillman, 2012, said, hey, you're a California resident. We don't have that statute here. We don't recognize them. So we're not going to recognize your out-of-state asset protection trust. So he created an asset protection trust 5 years before he was ever sued, completely disregarded. California still went in and then created a 10-year look-back period. So this is the issue that we're starting to see domestically. And so what you want is to create a hybrid. It's called a bridge trust. It was created about 30 years ago. And what it does is it combines the best of both worlds. It creates a fully foreign asset protection trust, in the Cook Islands, registered from day one offshore with the foreign trustee in the secondary position from day one, and then is built back to the US like a bridge. That's why it's called the bridge trust, just connecting two countries together. And the way we do that is by maintaining IRS compliance with the IRS codes. And we're just maintaining compliance with USC section 7701 called the court test and control test. So what this does is it classifies your foreign offshore trust as a domestic offshore trust. And then that means it's going to be cheaper on cost, generally around $30,000 to set up. It's going to be cheaper on maintenance, generally around $2,100 to maintain in annual fees. And you still have the St. Germain protection, which is anonymity. You don't have to have any really disclosures at all on what's held in that trust. But the benefit is once you get sued and we declare a state of duress, we drop the domestic compliance. The trust is automatically within 2 days a fully foreign asset protection trust with the statutory non-recognition of the Cook Islands. And then if we have to transfer the equity out, now you're fully protected. So you got the benefit of both.
Got it. So you mentioned the cost. I mean, 50,000 one way versus the bridge being 30,000. For somebody that's more domestic, investor that has multiple domestic assets, maybe they've gone as far as just setting up LLCs. Is there a map? Are you able to work with what they have to strengthen it and make it more impenetrable? And if I said that right, unable to penetrate the protection.
Yeah. So what you do is you just look at where you are on the sliding scale and your liability wise, and realize those systems, it's scalable, flexible, and you grow. So when you're starting out, you shouldn't be looking at a bridge trust or a foreign asset protection trust. That would just be a very expensive solution for something that doesn't carry much liability. So if you were to call and say, hey, I'm just starting out, I want a bridge trust, I would say, no, you don't. You're not ready for that yet. You would be starting out with an LLC and insurance. Generally, $1,000, to give or take law firm for an LLC for asset protection. Then you get insurance. After you get to about $250,000, $500,000 net worth, that's when you really should be looking into cleaning up your system, because by that point, you probably have a couple LLCs, 2 to 4 LLCs, plus a couple, 4 to 6 units. Your liability is expanding, your passive income's expanding, you're a more visible target. You need to clean up your system and add a second layer of protection. So around that 250, 500,000 net, worth mark, add the limited partnership. When you hit about 1 million net worth is when you want to start looking into adding the asset protection trust or a bridge trust. And then if you're under 1 million, you're like, hey, I really want an offshore component. I just don't have $1 million net worth. There is a trust called a quantum living trust, which is about $14,000, with a limited partnership. So that's like $8,200 just for the trust is what they generally go for. What that is, it gives you offshore components. It's just not fully registered offshore from day one. So it's called a quantum trust because there's a sub trust that's created domestically, but that secondary trust relies on the quantum trust for its offshore component. And then you can quickly change out, once you hit that $1 million net worth mark, the quantum trust for a bridge trust. But that's a good entry point for someone who wants offshore protection but isn't ready yet for a bridge trust.
Got it. And for somebody that's, the word trust gets thrown around a bunch. And I don't know that people have a deep understanding of that. What we've been talking about here is asset protection trust.
Yes.
How does that fit in with somebody that's doing like a personal trust, for when they die, transfer of assets?
Great question. So trust, there's a lot of different types of trust. An estate planning trust, like a revocable living trust, is not an asset protection trust. You still will need one of those, or you don't have to have one, but you should have one. The way those would work with asset protection trust is they're named in the asset protection trust. And then when you and your spouse die, then the assets would be distributed per who you name as the, the beneficiaries of the assets in that trust. And so that is very flexible. They work together. Your revocable living trust wouldn't own the assets. It would just essentially be your medical directives, your financial directives, naming your beneficiaries. And then you would have your assets in, the structured tiered up system, LLCs, LPs, and then the asset protection trust. And then when you die, the assets would be distributed per the revocable living trust. But just remember, revocable living trusts aren't asset protection trusts. They're just estate plannings to avoid probate, which means avoiding the courts telling you where your assets go, and death taxes. And, the death taxes have been increased to, I think it's like 24.1 million. So for most, it only really affects the 0.01% of people in society. So you're not talking about losing your wealth, because you died. Generally, you're talking about lawsuits. But you do want to avoid probate because you don't want a court telling you where your assets are going to go. You want to direct where your assets go and have control over that.
Got it. I appreciate you kind of distinguishing between the two there and kind of explaining how they work together. Because like I said, trust is a word you hear a lot, but not always understanding that there's a difference in how they work together. So that's good. Brian, is there anything more you wanted to cover on that? If not, I was going to ask if we could shift gears here for a second.
No, I think we covered a lot, and without frying all your listeners' brains, listen to this a couple times.
Yeah, it's definitely a heavy load there, but I do appreciate you going in depth in it and just kind of the simple model there of the comparison to going out and playing in the winter. You got your base level, mid level, and then your outer level. I think it's a great analogy. It's easy to understand, and I think you did a good job with that. I appreciate that. So if we could, I'd like to shift gears for a second. As I've mentioned, by day I'm an insurance broker, and I work with my clients to assess risk and determine what to do with risk. And there's three strategies we typically look at. The first is we ask, can we avoid the risk? If that's not possible, we look to see if we can minimize the risk. And when neither of those are an option, we look to see if we can transfer the risk. And that's what an insurance policy is a risk transfer vehicle. And I like to ask my guests if they can look at their own situation, whether it be clients, investors, tenants, market, et cetera, however you want to frame it. I invite you to do so. But if you can take a look and identify what you consider to be the biggest risk, and again, for clarification, I'm not necessarily looking for an insurance-related answer. And so if you're willing, I'd like to ask you, Brian Bradley, what is the biggest risk?
I think the biggest risk is not thinking that you have any. And I think ignorance is the biggest risk, because I have a lot of clients who call eventually, it's like, why did you wait so long? You have $20 million, of assets that are unprotected. And they had no clue where their risk even lies, because they thought, well, I'm heavily mortgaged. And so I didn't think that I needed to protect anything, but then they have, a lot of equity in that, and they didn't think equity needed to be protected. So I think it's just a matter of looking at your whole life structure and talking to a professional like yourself and myself and saying, what's your day job? What's your normal life like? What are the age of your kids? Where's the liability just in your general life? Where's your liability in your professional businesses? And where's the liability in the things you own and how you own them? And then get a good assessment and knowledge base on that. Then once you understand where all the risk and liability comes from, then you have the knowledge to start thinking, what do I do about this, and mitigate those. But if you don't take the first step to even analyze where your personal life and liability comes from, that I think is the biggest thing. Because if you think of it like a pie chart, there's the things I know, there's the things I don't know, and then there's the things I don't know that I don't know. If most of your liabilities are things that I don't know, you're in for a rude awakening. So I like to shrink that piece of the pie first and start educating people to where once I know I don't know this, I can ask the questions and start solving that.
No, that makes a lot of sense. And unfortunately, there's a lot in that pie graph there of the risk I don't know that I don't know, and that's kind of ever changing. Brian, where can the listeners go if they'd like to learn more or connect with you?
Yeah, they can jump on my website, www.btblegal.com. I have lots of educational information, lots of frequently asked questions sections, media, um, educating seminars that we go and talk to. So it's a great place for resource. A lot of, like I love case law, so I have a whole legal resource case law library on there for people to actually go through and see case law of asset protection and how things play out and work out in real world trials. They can email me, Brian, Brian at btblegal.com. I'm on LinkedIn. I love LinkedIn as a way to stay connected and educate people.
Awesome. Well, Brian, this has been a great opportunity to learn about asset protection. I really want to say thanks for taking the time. I've enjoyed it, learned a lot, and I look forward to doing it again soon.
Yeah, thank you for having me.
All right. For our listeners, if you like this episode, don't forget to like, share, and subscribe. Remember, the more you know, the more you grow. That's all we've got this week. Until next time, thanks for listening to Commercial Real Estate Pro Network's CREPN Radio.